Good morning. You're Nathan Lamel, Senior. And Mr. Lamel was previously in court and entered a plea of true to count one in a motion to revoke deferred probation on probation for evading arrest or detention with the use of a vehicle. And that was from February 17th of 2025. Count one that he pled to was the count where he was arrested for a burglary of a habitation. It was not necessarily that he had committed it, but that he had been arrested for it.
And Judge,
Go ahead.
So you're aware, the motion reads kind of funny that you pointed out to us last time. So I could technically abandon 1 and 2. I just kept them there for your review. I have corrected them in 7 and 8. I believe.
Okay, so
That's
there
why
was a
it's
first amended.
Yes, ma'am.
So we need to go through that first amended.
Correct. And then Ms. Branch will be here to testify in place of Ms. Jefferson if those pleas don't change.
Okay, hold on a second. Let me pull this up correctly. So let's go through that motion. Mr. Lamel, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, sir. You can put your hand down. And will he waive the formal reading of the first amended motion to revoke unadjudicated probation?
So waived.
So again, and this is 24 DCCR 0826. You have a first amended motion to revoke your unadjudicated probation. Shows you were placed on probation February 17th of 2025 for evading arrest or detention with the use of a vehicle, and that was a 5-year deferred probation. Is that correct? It alleges you violated your probation, and I'm going to go through the whole thing again, just because I don't have the other one right in front of me. It'll be easier. So count one alleges that you were arrested. Okay, so did you want to?
Abandon 1 and 2, Judge, to show that they were correctly reflected in the first amendment 7 and 8 committed.
All right,
That's
so,
what you didn't like the arrested for last time?
well, I mean, arrested for is fine, but it's not a violation
Correct.
of your probation.
Correct.
Okay, so 1 and 2 will be abandoned. So count 3 alleges that you failed to report as directed to the probation department March 5th and April 9th of 2025. And is that true or not true? True or not true?
True or not?
Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. Today, we're watching Nathan Lamel's probation hearing unfold, a complex case involving evading arrest, multiple substance violations, and a burglary allegation. Already, you can sense the tension in the room as the judge methodically goes through every count. And yes, there are twists that might shock you. Keep your eyes on the key moments where the probation violations meet legal nuance. It's not just about guilt, it's about what the court considers corrective versus punitive. This is the kind of case that shows how probation isn't a free pass, and every action counts in front of a judge.
Count 4 alleges that you provided a urine sample May 1st of 2025 that tested positive for tetrahydrocannabinol. And is that true or not true? That's marijuana, THC. Count 5 alleges that you were at a location other than your residence at approximately 3:01 a.m. April 26th of 2025 in violation of your probation. Is that true or not true?
Yes, sir.
Count 6 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that on May 1st of 2025 you tested positive for alcohol. And is that true or not true?
Yes, sir.
Count 7 alleges that you committed the offense of burglary of a habitation April 26th of 2025. And is that true or not true?
No, sir.
And count 8 alleges that you failed to avoid injurious or vicious habits and refrain from behavior harmful to others, and that you were aggressive towards both Beaumont police officers and the complainant, Aronia Parkerson, on or about April 26th of 2025. And is that true or not true?
No, sir.
Here's where it gets interesting. Nathan admitted to multiple violations, missing probation check-ins, testing positive for THC and alcohol, even being at the wrong place at the wrong time. Legally speaking, this is huge. Probation is conditional freedom, and these aren't minor slip-ups. They are technical violations that could have led to immediate incarceration. Notice how the judge pauses, clarifies each count, and even discusses MDMA versus ecstasy. That's not drama, it's legal precision. And here's a question for you. Do you think the system gives too much leeway for substance abuse issues, or is this structured intervention necessary to actually help someone turn their life around?
Count 9 alleges that you provided a urine sample May 1st of 2025 that tested positive for ecstasy. And is that true or not true?
Your Honor, if I might, I don't think ecstasy is listed in the Controlled Substances Act. It would be MDMA. That's the street vernacular for methylene dioxymethamphetamine.
Okay, so if it's the same thing and it's just another name for it.
But I'm not sure that would be a violation. What would be characterized as ecstasy? If they want to amend to allege MDMA, that would.
Ms. Malfino?
I'll make that oral amendment, Judge, to change ecstasy to reflect MDMA as worded in the Controlled Substances Act.
All right, so any objection to that?
No objection.
All right, so that count 9 alleges now that you provided a urine sample that tested positive for MDMA, which is also ecstasy. Is that true or not true? Did you enter your pleas of true to counts 3, 4, 5, 6, and 9 freely and voluntarily?
Yes, no.
And because they're actually true?
Yes, no.
All right, so with regard to the burglary of a habitation, Ms. Malfino, what is the state's position as far as wanting to, do you want some time to
Judge,
prove that, or?
I will defer to whatever the court would like me to do. The complainant in that case has filed a non-prosecution affidavit and has also indicated to my office that she does not wish to cooperate in that case.
Okay.
I do believe Ms. Branch can testify with respect to that injurious or vicious habits in her reflection or read of the police report if Mr. Kimmler wouldn't object. Otherwise, if you would like me to get those officers to detail his behavior on that night, I can do that, but she has not been cooperative with me.
Okay.
Obviously, Your Honor, I would like the opportunity to cross-examine if the state does attempt to prove it. I would just observe that whatever conduct Mr. Lamel did engage in didn't result in criminal charges being filed to the level of resisting or harassment or anything of that nature, retaliation.
So we already did the updated pre-sentence report, and the recommendation in that report, it was unagreed, and the recommendation at that time was that he would benefit from both tracks of ISF. He can't do both tracks, but to go in and do the substance abuse track, followed by JCDI, anger management. Ms. Malfino, since it can't go if the other case is pending, I guess based on what you're telling me about the complainant in the other case, what is your position on that?
To not proceed on that case, Judge.
Okay, so there'll be a dismissal.
If we order him to ISF, I will file a dismissal today so that doesn't hold him up. But if that's also Ms. Branch's.
Is that still your position?
Yes, ma'am.
Cognitive track or substance abuse, Your Honor?
Well, substance abuse is clearly an issue. I think I would rather do substance abuse and then JCDI and then whatever other behavioral thinking, moral recognition or something like that once he's out, and so that we get the more intensive substance abuse before he gets out for JCDI would be my thought. What do you, or would you think cognitive track would be better? You do? Okay. So what is the status of the relationship with the complainant? What's her name?
I'll represent to the court.
Aronia Parkerson. I'm asking him. I'm asking
I
him.
understand that she's present outside of the court.
Okay. So what is your status of your relationship? Are y'all still together?
Yes, no.
Do you want to ask her some questions since she's here?
Maybe so, Judge, if I may. I didn't realize she was.
You want to go visit with her for a minute, or do you want to have her brought in?
Oh, we can just have her brought in.
Would you please call the name Aronia Parkerson? If you'll scoot over just a little bit towards your attorney. Ma'am, come right over here. You just come on up right here. Would you please state your name, please?
Ariana Parkinson.
And Ms. Parkerson, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Ms. Malfino?
Thank you. Ms. Parkerson, can you please describe for the court the nature of your relationship with the defendant, Nathan Lamel?
He's my boyfriend.
And is the gentleman in the orange to your left, is that Nathan Lamel?
Yes, ma'am.
Your may the record reflect that the witnesses identified the defendant in this hearing.
The record will so reflect.
Judge, on Saturday, April 26th of this year at approximately 6:15 in the morning, were officers of Beaumont Police Department dispatched to your home in reference to a burglary call that had been made.
Yes, ma'am.
Can you tell the court about that?
Me and Nathan had got into a disagreement. I really don't recall what the disagreement was about, but the first time they were called, he was trespassed, and the officers explained to me that if I called them back, that the trespass warrant will be voided. I was okay with that because I knew I was going to call him back eventually. But he came back a second time, which made me call them again because he wanted to talk about whatever we had a disagreement about, but I didn't want to at that moment. I was going through a lot. I had just had my son a month prior, so I was dealing with postpartum. And at that moment, I just didn't care to hear what he had to say. But he knew I called the police back, but my dad was also in my house, and my dad wanted to talk to us both to see what the problem was between us, which is why he stayed, and he was arrested that night.
At approximately 5 a.m. that morning, or thereabouts, 5:20, were you awake and on the sofa in your living room, I'm sure probably with your new baby?
Yes, ma'am.
And what did you hear going on in your bedroom? Breaking of glass, rustling of things around?
Yes, ma'am.
And tell the court about that. What is it that you observed? Did you observe the defendant coming forcibly into the window of that residence?
I wouldn't say forcibly.
Had you given him permission?
No, but I heard him trying to open the window, and at that point, I started recording a video just to get him away once the police was brought back.
Did you feel like that entry into your home was with the intent to possibly assault you based on what had been happening previously that evening and with respect to the nature of y'all's ongoing relationship?
No, ma'am, I don't feel that I was in any harm. He just wanted to talk.
So you don't believe that it was his intention to assault you, or that he could have possibly assaulted you in that scenario there?
No, ma'am.
But you still felt it necessary to contact the police on multiple occasions that night?
I just wanted him to leave. I didn't want to continue to talk about the situation. If he would have left the first time and then came back the next day, we could have revisited our situation. Just like when he was released 3 days afterwards, I think accusation is what it's called. He came back to my home and we talked about the situation, and moving forward, we've been good ever since.
Okay. Is that baby his?
Yes, ma'am.
Okay. And is it true that on May 10th of 2025, on August 7th of 2025, that you came in and gave a non-prosecution affidavit signed with Investigator Troy Robinson of my office, indicating that you did not wish to pursue the burglary charges against Mr. Lamel?
Yes, ma'am.
And is that what you're telling Judge West here this morning?
Yes, ma'am.
And has he pressured you or made you any promises or coerced you in any way?
No, ma'am. I did this of my own free will.
And do you understand that if those charges are dismissed, they're not going to be refiled?
Yes, ma'am.
And that you are taking your safety with Mr. Lamel into your own hands?
Yes, ma'am.
And are you asking the court to follow any agreement that she decides to make with respect to sending him to some substance abuse treatment, so that hopefully when he gets out, your relationship can be more effective
Yes, ma'am.
and he can help you raise those babies?
Yes, ma'am.
Thank you, Vanessa.
No questions.
Thank you, ma'am. You can go have a seat. Okay. Not a good way to handle that situation, was it?
Now watch the courtroom tension rise as Nathan's girlfriend, Aronia Parkerson, takes the stand. She explains what happened during the April 26th incident, conflict, the police being called, and Nathan's return to the home. Legally, this is delicate. She does not believe he intended assault, but the multiple calls to police still form a basis for probation concerns. From a courtroom perspective, her non-prosecution affidavit significantly affects the judge's discretion, highlighting how witness cooperation can literally change the outcome of a case. Audience, here's your engagement point. Do you believe the non-prosecution decision is fair, or could it send the wrong message about accountability in domestic disputes?
No.
When you hear it out loud, how does that make you feel when you hear out loud what you did that night?
A little disappointed.
Not good for your baby, not good role model, not good for the relationship, and not good to keep you out of jail or prison, right?
All right.
So what I'll do then, based on that and based on her representations and probation's willingness to try to help you so that you can be successful, is I'm going to find that you entered your pleas of truth to counts 3, 4, 5, 6, and 9 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to follow this agreement, or not agreement, I'm going to follow the recommendation, and I'm going to continue you on probation. I am going to extend your probation for 1 year. I'm going to order that you enter and successfully complete the substance abuse track of the ISF program. And then when you're released, your aftercare will be through the JCDI program. You will also be required to follow any other new recommendations or classes with regard to making better decisions, cognitive thinking, things like that. This is all meant to help you be successful. I want to make sure you understand, though, that if you come back here again on another motion to revoke, you're probably not going to get the same. I'm sorry?
I'm sorry.
Yeah, no, you're not going to get all of this again. Does that make sense?
Mm-hmm.
You're likely going to be going to prison, and you could go to prison for up to 10 years. You could do that today. I could send you to prison for 10 years just for the violations you've already had that you agreed to, the testing positive and all that. I don't need a new case. I don't need any of that. I can send you to prison today. I don't want to do that. I want you guys to work things out, but you've got to make things where that works in a very productive and nonviolent and non-confrontational, sober way. Okay? So, probation will let you know what all, again, that you need to do, but you'll go from here to ISF. Once you get out, you'll be in JCDI. No violations. Okay? All right. Good luck to you, sir. Okay. Give me just a second. All right. Are you Victavia Sanders?
Yes, ma'am.
All right. Give me just a second.
So plead true to them. We need the community service in Montana. Plead true to my community.
So there's still, our tablets are still messed up. And we only have one? We have two. Oh. Sorry, it's coming. All right, will she waive the formal reading of the motion?
So wait.
Ms. Sanders, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. And so, Ms. Sanders, in cause number 22-39884, I have a motion to revoke your community supervision. Shows that you were placed on probation May 1st of 2023 for the offense of theft of property with previous convictions, and that was a 2-year state jail term that was probated for 5 years. Is that correct?
Yes, ma'am.
It alleges that you violated your probation Count 1 alleges that you committed the new offense of theft of property with previous convictions July 31st of 2025. And is that true or not true?
No,
Not true.
you're not true.
Count 2 alleges that you failed to provide verification of performing the community services required. Is that true or not true?
Yes, ma'am.
It's true. Yes, that's true.
Not true.
Count 3 alleges that you're behind in your court-assessed fees as of August 19th, 2025 in the amount of $919. And is that true or not true?
That's true.
Did you enter your pleas of true to counts 2 and 3 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your pleas of true to counts 2 and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. But I'm going to reset your case for a sentencing hearing and ask the probation department to do an updated report. And we'll need, I guess, some time for witness.
Probably about an hour, Judge.
Okay.
We can do it at 11 o'clock on this.
Okay, so we'll reset it to where we have about an hour or so for any prove up of count 1.
And she's requesting a bond, Your Honor, although it is a straight probation case.
Has there anything been filed?
Should have been last night. But he filed it.
Yeah, we're not having any trouble with those. He dropped it down. Sorry.
Make it work better.
Let me make this notation first.
You get out if she doesn't. You know.
Mr. Smith, what is your position with regard to a bond?
State's opposed to bond, Judge. We're seeking state jail time and the new offense as well as.
Speak up, please.
The state is seeking state jail time in the new offense as well as the MTRP.
Okay, let me look at something and then I'll. I should be able to go back and see. Yep. So I'm going to take a look at the original pre-sentence report. That'll just help give me some information about history and what got us here in the first place. No, that's denied at this point. This is her she's on probation for her 3rd felony and now allegedly committed her 4th. So that's denied. We'll get it set for a sentencing hearing and take care of it on that date.
Yes,
You can
sir.
go back with the bailiff.
Okay.
Good morning, sir. You're Calvin Randall. And Mr. Randall has 3 cases, and 24 DCCR 1278, aggravated assault with a deadly weapon, 24 DCCR 1529, unlawful carrying a weapon on alcohol premises, and 24 DCCR 1530, an evading arrest or detention with the use of a vehicle. Mr. Eckhart, what is the announcement?
Judge, Mr. Randall was previously revoked on a different offense that's not listed here. Philip has made a very fair offer. And we were going to fill out a rejection this morning, but we need a little bit more time if the court will allow us. I think we're still kind of weighing our options.
Okay, and so what I'll do, any issues, Mr. Smith? So, Mr. Randall, I'm going to reset your case one more time. Mr. Eckhart will be out to visit with you about all your options, and we'll get an announcement at that next court date. All right, you can go back with the bailiff. Good morning, you're Traylon Hill, and this is cause numbers 24 DCCR 1500, 1614, 1615, and 25 DCCR 0436. And Mr. Matusko, what is the announcement on Mr. Hill's cases?
Your Honor, I believe I have all the discovery. Nothing has changed as far as a rejection.
Okay.
We'd ask the case be placed on the trial docket.
All right, then we will get that done at the first available trial docket and get it taken care of as quickly as possible. I understand that when it comes up, it may or may not be the oldest one, but based on the behavior and what the jail staff, and are we going, okay, we're going on more.
1, 2, 3.
Thank you. Let me get that pulled up properly. Are you Julian Garcia?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Garcia, in cause number 25, DCCR 1392, you're charged with the state jail felony offense of burglary of a building from June 26th of 2025. The indictment alleges you were previously convicted of theft of property, a state jail felony, February 5th of 2016, and that after that was final, you were convicted of unauthorized use of a vehicle, May 5th of 2022. And how do you plead to that charge? And are those prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty and true freely and voluntarily?
Yes, ma'am.
And because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
I do.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
I do.
Let's see. So the agreement's for 10.
He was recently sentenced in drug court to a 10 year.
And for the rest of the
Okay.
preliminary
The
term,
most he's received in the past, judges, several state jail sentences and 5 years.
Okay. All right. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Garcia is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty, and also find those prior convictions true. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. That will run concurrently with cause number 25, DCCR 0767. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas.
Yes, ma'am.
Good luck to you, sir. You can go back with the bailiff. Good morning, sir. Are you Braxton Hughes?
yes, ma'am.
And will your client waive the formal reading of the indictment?
Here we go.
Mr. Hughes, in cause number 25, DCCR 1124, you're charged with the second-degree felony offense of burglary of a habitation from July 19th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a cap of 4 years in prison, which means you're leaving your punishment up to me. And as long as I don't give you more than 4 years, I could give you 4, I can give you less. You're waiving any right to appeal. You understand?
Yes, ma'am.
You have an absolute right to have a jury come in and determine 2 things. The first is they could determine if you're guilty or not, and then you could leave your punishment up to that jury. If we go forward this way, you're waiving that right, and is that what you want to do?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Hughes is not competent?
No, Your Honor.
And also, sir, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
So I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Parker, and he'll present it to me on your behalf when we come back. All right, you can go back with the bailiff. Let's see, and are we only going on, I guess the 2 priors are on the same date, so those would. Well, they could enhance. Are we going on count one with the prior, just for enhancement purposes? I mean, for, I guess, jurisdictional purpose, not the other two?
Yes, Judge, with the court's permission, I know there are obviously priors.
They're
from
old.
quite a
Yeah.
bit ago in Orange County, and the theft in this case was $20 worth of food from the PTO that she concealed in her purse.
Good morning. Are you Joyce Daigle?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Daigle, in clause number 25, DCCR 1054, you're charged with the state jail felony offense of theft with previous theft convictions from June 5th of 2025. The indictment alleges you were previously convicted of theft November 8th of 2001 and then again December 1st of 2006. And how do you plead to that charge? And are those two prior convictions true? Did you enter your plea of guilty and true freely and voluntarily? And did you plead guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Daigle is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of theft of property, find those two prior convictions true, and sentence you in accordance with your agreement to a term of 10 months in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. Good luck to you, ma'am. You can go back with the bailiff. Good morning. Are you Kadesha Eli?
Yes, ma'am.
And will your client waive the formal reading of the motion?
She does, Your Honor.
Ms. Eli, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. And will she waive the formal reading?
She does.
I already said that, didn't I? Okay, Ms. Eli, in clause number 23 DCCR 0066, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation March 19th of 2024 for the second-degree felony offense of injury to a child, elderly, or disabled individual, and that was a 7-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges that you committed the new offense of theft with prior theft convictions, July 7th of 2025 in Orange County, Texas. And is that true or not true?
True.
Count 2 alleges that you failed to report as directed to the probation department May 19th and July 22nd of 2025. And is that true or not true? Count 3 alleges that you failed to work faithfully at suitable employment and provide verification of that to probation. Is that true or not true?
True.
Count 4 alleges that you failed to remain in Jefferson County and that you were in Orange County July 7th, 2025 without permission. Is that true or not true? Count 5 alleges that you have failed to provide verification of performing community service hours as required. Is that true or not true?
True.
It goes from 5. Oh, there it is. Count 6 alleges that you failed to provide. All right, so how do you plead to that charge?
Yes.
And are those 2 prior theft convictions true?
Yes.
All right. Did you enter your plea of guilty and true freely and voluntarily?
Yes.
And because you did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal? So if I follow the agreement, you can't change your mind. You understand?
Yes.
Okay. And do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Castile is not competent? All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft. Sentence you in accordance with your agreement to a term of 45 days in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Before I hand this to you, so all of a sudden you just decided to start stealing, and within 2 months you've got a felony instead of a misdemeanor. So I want to,
I was hungry.
Well, I understand, but I just want you to understand there's other places you can go in town to get food to where, hang on, I'm just trying to make this, you're going to get out of jail quick here. You got a great deal.
1 through 8 are the same counts on each. 9 and 10 are different.
We have great, we'll agree to abandon count 4. That's the 10. I'm printing the other one too, just because it's going to be hopefully easier and hopefully it'll print. It should be on its way. All right, sir, in cause number 24, DCCR 1791, I also have a motion to revoke your unadjudicated probation. This one shows you were placed on probation September 24th of 2024 for theft of a firearm, a 3rd-degree felony, and that was also a 5-year deferred probation. Is that correct? Each of these cases allege that you violated your probation. Count 1 in each case alleges that you committed the offense of unlawfully carrying a weapon May 12th of 2025 in Jefferson County, Texas, and is that true or not true?
True.
Count 2 in each case alleges that you committed the offense of unlawful carrying a weapon May 25th of 2025 in Jefferson County, Texas, and is that true or not true?
True.
Count 3 alleges that you committed the offense of a minor in possession of alcohol May 25th of 2025, and is that true or not true?
True.
And then the state is abandoning 4, correct?
Each.
In each case. Count 5 in each case alleges that you committed the new offense of resisting arrest or transport May 27th of 2025, and is that true or not true?
True.
Count 6 in each case alleges that you failed to report as directed to the probation department February 10th and May 15th of 2025, and is that true or not true?
True.
Counts.
Just technical, so we can amend it now.
All right, state abandons 7 through 10 in each case.
No objection.
As we wrap up Nathan Lamel's probation hearing, the judge finds him guilty on counts 3, 4, 5, 6, and 9. But in a show of judicial discretion, he is allowed to continue probation with extended conditions. Nathan must complete the ISF substance abuse track and follow up with JCDI programs. This structured approach is meant to help him rehabilitate rather than immediately incarcerate. The takeaway? Probation is not just about punishment, it's about carefully balancing accountability and support. And remember, any further violations could lead to serious jail time, up to 10 years. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Did you enter your pleas of true in each case to counts 1 through 6? I'm sorry, minus 4. So 1 through 3 and then 5 and 6. Did you plead true to those freely and voluntarily? And did you plead true to those counts because they're actually true? In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed those, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you've reached in each of your cases, that you will be waiving or giving up any right to appeal? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Williams is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true and in each case freely and voluntarily to counts 1 through 3 and 5 and 6. Find those counts true. Find sufficient evidence in each case to find you guilty. And cause number 23, DCCR 1801, find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 5 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 24, DCCR 1791, find sufficient evidence to find you guilty, and at this time find you guilty of theft of a firearm, 3rd-degree felony. Sentence you in accordance with that agreement to a term of 5 years in the Institutional Division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm going to hand you in each of these cases trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I'm also going to hand you, and you need to listen carefully to this one because I'm not sure what's going on with you and all this gun stuff. Apparently you think it's cool to steal guns, have guns when you're not supposed to, and it's landed you now going to prison at, how old are you? 20 years old. You're going to prison because you can't keep your hands off guns, really. So because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. If you possess a firearm or ammunition, charges could be filed against you, and those charges are 3rd-degree felonies. So it's no more UCW, unlawful carryings. It's a 3rd-degree felony, felon in possession of a firearm, because you're now a felon. Do you understand? If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, I'm handing you the trial court certification in that document now. I'm also going to sign, as part of the agreement, a dismissal in cause number 25, DCCR 0868. All right, you can go back with the bailiff.